Welcome to the Paducah Human Rights Commission's TV show, Raising the Standard. My name is Gary Reese. I'll be your host today, and Dr. Bernice Belt is our co-host today. And today's segment will be on the constitutional law. And we're very happy to have with us Wes Sullenger from the Sullenger Law Firm. So,
thank you. I'm glad to be here.
We want to go into some basics in regards to constitutional law first. Kind of talk a little bit about what that is and the scope of the law, and then maybe as we go we'll get into some specifics. If you don't mind, just kind of give us a little bit about this area. We know you're the expert in constitutional law. Kind of give us just an overview of the scope of the law and how it has an impact on average Americans.
Sure. The Constitution is our founding document. The national Constitution goes back to 1787 when our framers walked away from the Articles of Confederation we had at the time and created a new Constitution. And the point of the Constitution is not to regulate the day-to-day matters. The point of the Constitution is to be the big picture document. It creates all our government and sort of the basic functions they do. It creates the legislative branch, it creates the executive branch, which is the president, and it creates the judicial branch. And it sets out the processes for how they get elected, for who is eligible to vote, for how votes get counted, and then from the very beginning, they could see that we were going to need a little bit more specific than that. So they created what's known as the Bill of Rights, the first 10 amendments to the Constitution. And those set out some specific rights that people have. And then the 10th Amendment says that everything that's not spelled out in the Constitution is reserved to the states. So each state has its own constitution that sets out how it governs itself. So in Kentucky, we have a very similar structure. We have the General Assembly, which is the legislative branch. We have a governor, that's the executive. We have a judicial branch. But not every state does it exactly the same way. Some of them have single branch legislatures where we have a Senate and representatives just like the federal Congress. Some states have what's called a unicameral legislature with only one house. So the states have some rights that the founders of the nation left to them. And then all the day-to-day details kind of get worked out. So for example, the First Amendment says you have a right to free speech, a right to petition the government, a right to air your grievances, freedom of the press, and freedom to exercise your religion. Okay, well that's fine. What does any of that mean? Well, the Constitution doesn't say exactly what you have a right to free speech means. That's left to Congress to put some rules on, and then the courts to decide whether those rules are consistent with what the Constitution means when it says that an individual has a right to free speech.
Right. Just so our viewers are clear on the timeline, many, unfortunately, don't know the timeline, and I had to go back and do some homework because I needed to refamiliarize myself with what I learned in grade school and high school and what have you. Our U.S. Constitution was drafted in Philadelphia in 1787, ratified in 1788, and put into effect in 1789. So it's been around for a long time, and it established a strong central government in place of the Articles of Confederation, as you mentioned earlier. And they're basically a set of rules that govern the conduct of the organization or nation. And many Americans may not believe that conduct and decorum have been operated well, in their lifetime. But the rules were established as a concept to establish character and structure. And so our Constitution is the oldest, being 1787, and written as a national Constitution of the United States, which you also mentioned a moment ago. And when I was studying constitutional law, and we didn't call it that, we called it other things, you know, other core studies in high school and college level. But when I was studying it, oftentimes it was very confusing, because then and now and how things are done in the 20th and 21st century have caused some confusion. And so wanting to do a show, and by the way, ladies and gentlemen, this is going to be an hour long because there's a lot and we don't want to lose you. And so we appreciate having this opportunity to educate so that at times in times of need, it can be the foundation for mediation and eventually reconciliation when there are some constitutional laws that have been harmed and people have been hurt here, there, and everywhere. So having said all of that, what parts of the Constitution would you say, and you do have expertise, that's why he's here, y'all, the parts of the Constitution that have been diluted, so to speak, would you say?
Well, you know, that's a great question, and it's kind of hard to say. You know, in some ways, you know, everything is an ebb and flow in constitutional law because our government is run by humans.
Yes.
And personal desires change over time. Courts interpret things a certain way for a while, and then they change. So in the early parts of the 20th century, particularly the New Deal era, the courts ended up striking down initially an awful lot of what President Roosevelt had proposed, but there was so much public outrage that through some historical matters that I wrote an article on, you can look it up sometime.
Yes, will do.
But through some historical mechanisms, the Supreme Court ended up sort of stepping aside and letting the popular will get its way. And then things were fairly stable for a while, but through the late 50s through early 70s, you saw a very civil rights focused Supreme Court. So you got a right to representation if you were charged with a crime. You got rights, I mean, the Fourth Amendment gives you a right against search and seizure, but there had been no penalty for that. And in the case of Mapp versus Ohio, the Supreme Court created the fruit of the poisonous tree doctrine, which says if your house is searched illegally and they find something, they don't get to use it against you. So it sounded great to have a right not against search and seizure, but it didn't matter until somebody decided there was a penalty for that. Speech, similarly, in the early part of the 20th century, there are lots of examples of cases of anarchists and communists who were punished and given severe jail sentences and a few executions for speaking out against the American government, American involvement in World War I in particular. As we get into the 60s, we get a whole lot more protection for speech. Leading up to 1984 in Texas versus Johnson, a soldier actually burned the American flag and was charged with a crime. And the Supreme Court overturned that, saying that it's clearly speech. He was trying to convey a message, and the remedy is more speech, not shutting down speech we don't like. Mm-hmm. And now we're kind of going back the other direction. In the last 10 years or so, we've gotten a much more conservative Supreme Court and lower courts. And we're seeing things kind of going back the other way, with courts being much more reluctant to, say, apply the fruit of the poisonous tree doctrine to keep out things that were illegally seized. But at the same time, technology is taking over, and well, what about GPS? Can the police put GPS on your car? Can they track your cell phone? Is that a search? Well, the Constitution, written in 1787, they didn't know what GPS was, or a cell phone, or a car, for that matter.
Right.
So how did that happen? And ultimately, the Supreme Court looked at that and concluded that applying GPS on somebody's car and following them around is, in fact, a search. It gives you particularized information about what a person's up to. And we don't have entirely clear rulings on cell phones yet, but the courts are leaning that way because our whole lives are on those little phones. And if they can break into those without a particular warrant, without showing a need related to some law enforcement purpose to do it, then what protections do we have? So, in terms of what's been watered down, I think I would point to a part of the Fifth Amendment, what's known as eminent domain. The government isn't supposed to be able to take our property. Private property, private ownership is another founding principle of the country. Of course, our framers were all landowners. Originally, to vote in this country, you had to be a landowner, and private ownership of property is something that was important because they came from Great Britain in a system where the king took everything. The king owned everything, and if you built yourself a nice farm and the king wanted it, the king took it. And there's no way to get ahead in life. You are simply a vassal to the king. So we protect private property. And in order for the government to take private property, which of course sometimes the government has to do, maybe we need a new interstate. Maybe you need to, as we're seeing Houston hit with a hurricane these last couple days, maybe we need to fix the spillways and create better drainage systems. There are legitimate reasons for the government to take private property. But the government is supposed to, according to the Fifth Amendment, the government can only take property for a public purpose and by paying just compensation. Now, the easy question there is just compensation.
Yes.
Those cases get litigated oftentimes, but the courts can decide. They can get appraisers and figure out what the value of a property is and get you some money. Where it's been diluted is in the public purpose. We had a case a few years ago called Kelo against New London, Connecticut, I believe. And that was where the city of New London, Connecticut wanted to take some nice vintage, lovely homes in a nice beach area that had kind of economically depressed, perhaps, but these were nice homes, and they wanted to put up a strip mall. And the homeowners didn't want any part of that. They had lived in these homes for generations. These were family homes. And they said, you're not taking it for a public purpose. You're taking it to give to a private company to build a mall. And ultimately, the Supreme Court went the other way. The Supreme Court said that economic development is a public purpose. So even though you're giving all that development right to a private company, because it would have some impact on the local tax base, that was a public purpose. And there's arguments to be made in both ways, whether that's the right or the wrong decision. But certainly I think that does not fit with what you would think when you say public purpose. That's not the obvious meaning. So I would say we've seen some diminishment of particularly the right to land ownership when the government wants to take it.
Yes, and along those lines, it has been my observation that most of the time it has not been at fair price.
I think that's pretty fair. What is a fair price ends up being a judicial determination. I mean, the government, well, like in any negotiation, you offer less than you think it's worth. So the government's going to offer a fairly small amount. And that gets into a different issue, right. An economic ability issue. Those with the economic ability to hire a lawyer can fight that a whole lot better than those who are desperate for the money or who try to go it on their own. But even those with a lawyer, it ends up becoming a battle of experts and a court stuck in the middle, and a piece of property only has the value truly that we assign to it. So, I feel like my home is worth an awful lot of money because I have a lot of emotional, sentimental value tied up in it. And that's not what it's about. That's not what the judicial process does. The judicial process looks at numbers.
And that's a perfect example of why so many citizens really don't understand the Constitution, become so frustrated with it that they just shut down on it altogether, is because there are so many nuances that are involved in our modern day.
Certainly.
And another reason for this show. A matter of fact, while I'm thinking about it, we would probably want to do something in addition to what we're doing with this 1 hour long show, and using your expertise, Attorney Sullenger, in the months ahead, because the Paducah Human Rights Commission, just like with the city and other organizations, we really do have a tremendous responsibility to make sure that we're doing community outreach, that we're doing our part to inform and to give some kind of confidence in knowledge. And so, having said that, I'll move on to Chairman Reese, because I know he's got something really interesting to ask you.
I do want to back up just a little bit to the idea that the Constitution, and I've kind of fallen up on what Dr. Belt mentioned about the nuances and the confusion and all that. I think it's very important to understand that, and I'd like for you to kind of take this a little bit further, to understand that really the Constitution, especially the Bill of Rights, as they were originally, the original intent was really to place limitations on an oppressive government, and it was really to protect all of us as Americans. I guess that's correct. Is that a fair statement?
Absolutely, that's exactly correct. You have to remember the context in which we became a nation, which was over the course of a couple of generations, people had left Great Britain coming over here. And that happened for an assortment of reasons. Some left to flee religious persecution. Most of them were looking for money. Most of them were fleeing an oppressive king under whose dominion they were never going to be individually successful. So they came over here, and they began setting up communities, because that's what you do. And there was a royal governor in each colony or each area, but that person was still somewhat removed. And by and large, people set up economic markets, set up communities, set up lives. But it was all still subject to that guy overseas. If the king didn't like it, it didn't get done. He taxed us, took our products, insisted that so much of our crops, particularly cotton and tobacco, had to be shipped overseas to England before we could do any commerce on our own. Officially, the Church of England was still the only recognized religion. So what had they really gained by coming over here?
Right.
And eventually, the history is there. They got tired of that. We had a big party with some tea in Boston Harbor, and then there was a big old war. And after the Revolutionary War was over, we set up an initial government that didn't work particularly well, and by 1787 we get around to this. But the fear always was of government getting out of control. Liberty was the byword of the founding generation. If you read the notebooks of the Constitutional Convention, they're speaking constantly about liberty, or read the Federalist Papers. It talks about liberty, and it talks about the liberty of the majority. They were scared of the government and whoever might get into power. So the point of the Constitution was to set up a system to guide the government, but they realized that you can't assume people are actually going to do the right thing.
Right.
So you need to give the individuals some rights that can't be violated, to protect them from the government overreaching, or to protect people in the minority. Say, it was when you had everybody coming over, and you got Quakers and Shakers and small religious sects that were regarded as cults, at least under English law. Well, they're the minority, but they need their rights protected. As long as they're not hurting anybody, then they should have those rights. That was the framers' attitude. So absolutely, the Bill of Rights in particular was intended to provide individual rights to stop government from becoming too powerful.
Right.
What is the direct relationship between the Bill of Rights and the Constitution?
The practical answer is that the Bill of Rights is what got the Constitution to be a done deal, because we had these factions having an argument in the Constitutional Convention. The initial argument was between big states and small states, because you had the more rural farming communities of the South, Virginia, the Carolinas, into Georgia, and then up north in your Pennsylvania, New York, in that area, Connecticut, were much more urban by their standards of the day, much more market focused, much more sellers of products, not raisers of life and food. So we got some compromises within that led to a national government, but separate state governments that could push back against the national government. And that got Congress divided into two houses, where the Senate, we elect our senators now. Originally, they were elected by the state governments, while the people voted for their representatives. So the House of Representatives is popularly elected, and the Senate is a reflection of the state governments. So we got some compromises that got us to a constitution. That was the first argument. We solved the big state, small state problem. But then that led us to the problem exactly that I mentioned, is some people thought, we've set up a good system, we need to trust it. And there were some people who said, well, England had a pretty good system too. It just over time, it only worked for some people. So we had a big fight, and that's where we get the Bill of Rights from, is as a compromise to say that we're not going to put all these in the Constitution, because if we enumerated rights in the Constitution, it would just be way too long. But we're going to propose all these individual rights, these 9 rights, plus the 10th saying if the Constitution doesn't say it, the states get to decide it. So that becomes the Constitution that gets becomes the compromise that gets the Constitution over the hump, is we create this sort of addendum that specifically gives individuals rights against the government.
And within the Bill of Rights, what is the structure within or under the umbrella of the Bill of Rights? When someone Googles it or someone opens up a current, textbook, what will they see?
The Bill of Rights, what we call the Bill of Rights, is technically only the first 10 amendments to the Constitution. And those were, we call them amendments, but they came along with the original document. They were ratified at the same time as the Constitution. The Constitution itself has a mechanism to amend it when the public decides it's time. It's a very burdensome process, which the framers intended, because they don't want us, again, this was about protecting people against majority whim, protecting the weak from the powerful.
Yeah.
So if it can get amended easily, then whenever somebody gets good and powerful, they can change the Constitution to the way they want it.
Yeah.
And we're going to have a constant push and pull of things changing, and it's going to get ridiculous. So it is a burdensome process, which means it's only been amended 16 times since the original. We have 26 amendments now. The first 10 are the Bill of Rights, and then 11 through 26 are the things that have been added in the subsequent 230 years.
Well, Attorney Sullenger, before we go to break, then may I say this, and let's make sure that I'm right on this. Our Constitution spells out the equality of all men, and of course that would mean mankind, includes women and children, but at the same time allows flexibility for changes over time. So that would be a good summary.
Yes, absolutely.
All right, well, we're going to go to a break, and then we're going to come back, and we're going to dig some more. Thank you.
Thank you.
Welcome back. We're here with Attorney Wes Sullenger, and this is our segment on constitutional law. We'll continue. Dr. Bell, you had a question?
I do. Just so that we help everybody flow real well. The terminology can be very confusing, and when we don't understand what some terms mean, it may cause us to shut down altogether, and then we'll miss all the other important meat and the potatoes of things. So, Attorney Sullenger, if you would, define or explain the representative, the Senate, and Congress.
Sure. Article 1 of the Constitution creates the legislature, or the legislative branch of the government, and the legislature, at least in the federal system, consists of two branches, the House of Representatives and the Senate. And the two branches can sort of set some of their own requirements, but to be a member of the House of Representatives, you have to be age 25, I believe, and to be a senator, you have to be age 35, which is also the age the founders set to be president. That was old back then, I guess. It doesn't feel so old to me anymore. But in terms of functions, there are a few things that are specific. The House of Representatives handles money. Anything to do with money has to originate in the House of Representatives before it goes to the Senate. But otherwise, the two houses basically set their own rules and decide how they want to organize themselves, how they want to function. Representatives are elected. I believe they serve 2-year terms. So we have an election every couple years where we pick a representative. The number of representatives each state has is based on census data. The Constitution requires that they be proportional to the size of the state. But each state gets 2 senators. And I think I mentioned earlier that originally the state governments elected the senators, but the 17th Amendment to the Constitution changed that and provided for direct election of senators. So they serve 6-year terms. So every 6 years we go vote for our Senate members, and each state gets 2 regardless of population, which was one of those compromises I mentioned between big state and small state. So a huge state like Texas has the same number of senators as a tiny state, like say Maine perhaps, but Texas would have a whole lot more representatives than would Maine because it has a much larger population, and representatives are based on the census data.
Would it be fair to say, just generally speaking, that in terms of, I guess, proximity of the average person, citizen to the government, that a representative would be closer to, and the person might get better redress from a representative than a senator? Is that?
Yeah, in terms of redress, I don't know. I don't know how responsive anybody is within government. Sure. Right. But yeah, I mean, for example, in Kentucky, we have Senator McConnell, who's based out of Louisville. He has a Paducah office, which actually is 3 doors down from my office in my current building, but he doesn't hang out there. He has never been there. He goes between Washington, D.C. and Louisville for the most part. Right. And then we have Senator Rand Paul, who's out of Bowling Green. To my knowledge, he doesn't even have an office in Paducah. I could be wrong about that. Yep. So they're our senators, but they are much more remote, and each of them is supposed to represent the entire state.
Right.
Whereas representatives here in Paducah, or the 1st District, James Comer is our current representative, and he covers a section of Western Kentucky it may be all of what far western Kentucky. I'm not sure exactly how
Right.
his district runs, but certainly he does make appearances in Paducah, and he's been in Marshall County recently. You know, the local guy or girl, as the case may be, is typically going to be more accessible.
Right, okay. I want to, at this point, I think I want to get into some specifics, get kind of drill down into the Bill of Rights. And if you don't mind, just kind of give us an overview of the basic rights that we have that are provided by the first 10 amendments. And then I want to kind of get more specific and get into each of those in more detail.
Sure. You know, you have right to free speech, right to practice the religion of your choice, a right not to have the government impose a religion on you, a right to a free press, a right to petition government for redress of your grievances. And all those things I just mentioned are in one amendment. That's all the First Amendment, which many scholars believe that the founders put free speech as the First Amendment because the founders believed it was the key. If you can't speak out against the government, how can you change the government?
Right.
If you're being oppressed by the government but nobody knows it, then no one cares. So many believe that the First Amendment is first because of its primacy. We have a right to bear arms, which is the Second Amendment. The Third Amendment we don't see much anymore. The government can't quarter troops in your house. We don't have to let the Army put its barracks in my basement.
Thank goodness for that.
Yeah. That one, we don't hear much out of that one anymore.
Yeah.
We have a right to be free from unreasonable searches and seizures. Have a right to due process, what we mentioned earlier, with not to have your property taken without reasonable compensation. You have a right to a jury trial if you're being charged with a criminal offense. You have a right to a speedy trial. Let's see, I think I'm running out of rights. You have a right not to be subjected to cruel and inhumane punishment. And those are your basic rights. Everything else is sort of subsumed within those bigger picture rights.
Well, let's talk about the first one, because I obviously we're seeing a lot of things in the news now that have to do with freedom of expression. So is freedom, the idea of freedom of expression, is that something that's specifically laid out in the First Amendment, or is that something that has been interpreted, or is there any difference between freedom of speech and freedom of expression?
Well, the answer to your question is all of the above.
Okay.
Is it laid out? Yes, it is. Or is it something that has been interpreted? Yes, it has. The framers just said you have a right to free speech. Okay, what does that mean? What is it? Where? When? Can I say things people don't like? Can I call you bad names? Can I videotape the police doing things that I think they shouldn't be doing? What if you see a cop who's trying to radar people and give them speeding tickets, and I flash my headlights to warn somebody? Can I do that? The answer is yes. That case actually came out of Tennessee a couple years ago. But the cops arrested a guy and charged him with obstruction of justice for tipping off people to a speed trap. It turns out you have a speech right to convey that there's a speed trap ahead.
Interesting.
Constitution doesn't say that, but the courts have interpreted that. And free speech, free expression, there's really no difference between the two. The key difference is between speech and conduct. As horrible as it is to say, and I hate to even say it, but someone may say, they have a right to say, it sure would be a good thing to blow up a federal building to say how horrible the government is. That's speech, and speech is protected. Conduct is not protected. Blowing up the federal building is a crime. Taking a step to blow up the federal building is a crime. But what's the difference? What is the difference between speech and conduct? Isn't the purpose of speech to cause conduct or to stop conduct? Well, excellent point, Wes. I'm glad you said that. It's a continuum between the two. So the courts have said horrible speech is protected up to the point where it begins to incite violence. Okay. You have a right to say things others disagree with, even that they find horrible and disgusting, but you don't have a right to cause others to engage in violence. So it's a legitimate point to say someone should take down Senator McConnell. But if they begin speaking of takedown in terms that suggest a crime and not a vote against him, that becomes a problem. And when you get to the point of pushing others to take some action to cause physical harm, or preparing oneself, buying ammunition, casing, whatever, I don't even care to think about what would be involved in that.
Right.
But it is a continuum between speech and conduct. Okay. The speech is protected, but as it becomes conduct, things get a little dicier.
The freedom of assembly has been heavily in the news, especially in Virginia and other places across the country. What rights do people have in regards to protest and marching in public areas?
Sure. Yeah, I think I left assembly out when I mentioned the First Amendment a while ago, but obviously it's clearly related to a right to speech. And you have a right to assemble, which means to gather. My right to free speech doesn't have to be exercised individually. I can get together with other people to express that. Now, mentioned speech and conduct, assembly sounds a little bit like conduct because you're getting together and doing something. And so the courts have said that there has to be some limitation because we can't just have a million people showing up anywhere, anytime. So the courts have said that jurisdictions, localities, can put reasonable time, place, and manner restrictions on assembly. Okay. And that's simply to protect the environment, protect traffic flow, which is a big deal right now. Can you protest by blocking a highway? The answer to that's going to be no, but the courts haven't totally resolved that issue just yet. But I mean, they can make you get a permit, basically, is what it comes down to. And but they can't discriminate in giving the permit. The Nazis have as much right to get a permit as do the Black Lives Matter people, as do the Jewish groups, as do white Anglo-Saxon Protestant men over 40. I mean, as long as it's equal, then they can apply these reasonable time, place, and manner restrictions. But what's beautiful about our country is that think about up until the violence happened at Charlotte, think about that recent protest. It started with some neo-Nazi groups, and I have nothing good to say about their belief system, but they have a right to say it. We don't decide in our system whether speech is good or is bad. That's not for the government to decide, because our idea of good and bad changes over time. We learn from past experiences and decide that was bad, this is good now. So they have their right to speak out. The solution is not to shut them down. The solution is more speech. If we think their ideas are abhorrent, then we should get our ideas out there and let what the Supreme Court has called the marketplace of ideas. Put all the ideas in the marketplace and see who wins. But that requires more speech, not shutting down speech. So the beauty of our country is you had some white nationalists and Nazis protesting here. Then you had some counter-protesters that consisted of a bunch of different groups, some black groups, some just human rights in general groups protesting here. And then sort of in the middle, you had the government. You had police, National Guard folks. You had black and Jewish police officers protecting the rights of a Nazi to say you don't deserve to be working in a government job. And then you had some white police officers protecting the rights of people saying whitey in a uniform is the problem. And the government stood in the middle and protected the rights of everybody while it was speech. When it became a problem is when violence started, and the one we know is the guy drove the car into the crowd and killed that poor woman.
Right.
But I understand there was some other, not as dramatic, but some other violence that happened as well. The violence is not okay, but that's what the government's there for, is to protect from the violence while preserving the right of those people to say speech. I mean, you know those cops disagreed with a great deal of what they were hearing as they were protecting these people. But our officers of the government are sworn to uphold our government. So when the president takes an oath to swear to protect the Constitution, the members of Congress take an oath to uphold the Constitution. Our officers in the state take an oath to protect the Constitution of the United States and of the state of Kentucky. Our judges take a similar oath. Police officers take a similar oath. And we are binding our government officials to put the nation ahead of their personal beliefs, of their party, of their individual philosophy. That's what is supposed to happen. We can argue over whether that's happening perfectly in our system, but there's an ebb and flow that happens. Right now, we have a Republican president. Both houses of Congress are Republican. Well, for a while, a few years ago, we had the exact opposite. Look through our history, we go through these periods. We are mostly a center-right divided country, but every now and then we go to one extreme or the other, and then we pull back a little bit. Yeah. So it's just built into the design of our system, and in large part because we have the right to speak out and to assemble against ideas we think are stupid.
Yeah. With that in mind, and I think that's a very good point, with that in mind, the idea that there's some that believe that we should just trash or throw out the entire system, the entire Constitution, and rewrite that. Just give me your perspective on that.
Everybody loses a fight now and then, and you think, well, I was right, it's not fair, I didn't get my way, let's trash it all and start over. But start over with what? And how? And who? I mean, we got this document that has survived 230 years, and it has proved remarkably resilient because it does have some flexibility. I mean, it's well known the original sin of this country was slavery, and I think I mentioned earlier that initially to vote you had to be a landowner. Well, in fact, you had to be a white male landowner. But the framers actually built an end to slavery into the Constitution. It was a compromise because the southern states weren't going to give, but it says that slavery shall not end before 1808. But they could see from the beginning that that was an institution that was going to be a problem, which doesn't make it okay that it was there, but that was the society at that time. Over time, we came to realize that's not good. So we have a Civil War, Emancipation Proclamation, Civil War, and then we get 3 amendments, 13th, 14th, and 15th, are what are known as the Reconstruction Amendments. And the 13th Amendment frees the slaves. 14th Amendment makes everybody a citizen of the nation, which overturned a Supreme Court decision saying that while they weren't slaves, anyone of African descent was not a citizen of a state. So we get the 14th Amendment, we all make them citizens of the nation. Now the state doesn't have a choice. So we get around that problem. And then the 15th Amendment gives individuals the right to vote regardless of race and regardless of history of slavery. So we've dealt with the race problem there. And later on, we get the 19th Amendment that gives women the right to vote.
70 years later.
Yeah, eventually we got around to that.
Thank you,
Thought I'd
Chairman.
throw that in there.
But, you know, we were born out of this original sin that it was a white Protestant male country. And we've changed all of that. Are we perfect? No, we're not. We're never gonna be. But we're getting better. We keep getting better. And the fact that we're still having these fights over race relations, but while I can't say anything is necessarily getting solved, we're still talking about it. Maybe we're talking too much with fists as opposed to words sometimes, but we're still dealing with it. And we have the courts there. Our system creates separation of powers where we have Congress that makes the law. The two houses of Congress pass something and they send it to the president, who can sign it or he can veto it. If he vetoes it, then Congress can override that if they're really convinced it ought to be a law. And then once a law is out there, or we have other things now, not just laws, we have executive orders, we have regulations, things that aren't truly laws but have, I guess you would call them law-like qualities. And the courts are there, the judicial branch is there to review those. So we have these three branches that all do their individual thing, but their individual thing is to check up on each other. And that way we provide that balance. So we're arguing about race problems, about gender problems. Sexuality problems are a big deal lately. Transgender, should we have transgender bathrooms in public schools? Should that be required? Obviously you can have it. Should you be required to have it? Not an easy issue. There's not a clear societal determination on that, but Congress could make a decision on that. Well, in fact, the Obama administration had made a decision on that in a regulation, and then one court agreed with the Obama administration, one court disagreed with that. It's on its way up to the Supreme Court. Congress really has had no say in that particular matter just yet, but the president appoints the justices of the Supreme Court who get confirmed by the Senate. So when the Supreme Court makes that decision, it's being made against the backdrop of a recent Supreme Court justice who was put on the court because people voted for the Republican Party. So it all interrelates, and you know, it's become far afield from the assembly question we started with, but the point is that the assembly got us to where we are.
Right.
You know, the people started not believing in slavery, and we had a war about it. Literally, we had a war about it.
Yes.
And we're still having that fight in a lot of ways, but it's become other issues. Gay marriage hadn't actually been a fight all that long, but gay folk have been an oppressed class for the 20th century. And then really through a lot of assembly and a lot of speech, public attitudes changed. Whether you credit that with people liking Will and Grace, or whether you credit it with people having gay friends or seeing marches on television, whatever it was, some form of speech changed society's views. And eventually the Supreme Court concluded that the Equal Protection Clause that's part of the 14th Amendment requires us not to discriminate against people based just on an equality about them.
Right.
Well, I was wondering about this oath of allegiance, an oath administered to the elected representatives of a legislature to bind their loyalty to the country's constitution or versus an individual or a political party. Could you help us with that?
Sure. You know, and that's one of those things that sounds great in principle, but I think we're having a little trouble with in practice maybe.
Yes.
You know, the framers Gridlock was built into our system. The whole concept of checks and balances was meant to build in gridlock so that we couldn't act quickly or act based on fear or anger or those sorts of things. But, you know, they were landowning white men who were rich, who created a system of government that protected non-landowning people who didn't have anything. So they took very seriously the obligation to think about something bigger than yourself. And I don't want to get into political speeches, but I mean, certainly people question whether we still subscribe to the notion of being bigger than oneself. You know, it's not supposed to be about political wins. It's supposed to be about good of the country. And so I think I mentioned a while ago, each elected representative or judges, some of whom are elected in the state system and some of whom are appointed in federal and some state systems, and law enforcement officers are all sworn to take an oath pledging their allegiance to the laws of the Constitution, or the laws and the Constitution of the United States and the state they live in or work in. And that, you know, that is important. Certainly people, politicians or otherwise, should fight for their individual beliefs, but we've got to get something done at some point, and those oaths are supposed to be there to remind people that you've got to put country ahead of self or ahead of party at some point and get something done.
Along the way, we have actually talked about 6 of the 7 articles of the Constitution. The legislative branch, the executive branch, the judicial branch, the state, the amendments with it, which is Article 5, and amendment is simply what, a change or an adjustment or an enhancement to something that already exists.
Or an addition.
Or an addition. Well, it's the 7th one, if you would take a couple of minutes and talk about, which is ratification.
A ratification of the Constitution?
Yes, it's the 7th article of the Constitution.
Sure. Yeah, and that was just that, you know, even, again, these were people who came from that authoritarian monarchic system, and they were scared to death of top-down power. Even though the guys, and it was all guys, so I say guys, who are putting this together, were the top. You know, once we'd broken away from Britain, George Washington, Alexander Hamilton, Benjamin Franklin, all the names you know, and a few that you don't, they were the top guys in the country. If power were going to be top down, it would have been them. But they were absolutely terrified of top-down power and understood that, at least hopefully, this experiment in self-government was going to outlive them. So they needed some system to ensure that when they're gone, there's still no top-down power. So before the Constitution could be ratified, they didn't just say, hey, we got a new Constitution, you're going to like it, it's good stuff. They could have. I mean, we had gotten rid of the Articles of Confederation, we were no longer part of Great Britain, we were on our own. They could have said, here's the rules, have fun with that. But they didn't do that. They said that, you know, each state, or well, state at the time, I forget how many exactly we had by that time, but 14 or 15, I believe. Each state got to have its say. Each state, through its own state government, had to approve the Constitution and the Bill of Rights. They went along together. Each state had to vote in its own constitutional convention in its home state, and only, I believe it was 3/4 had to ratify, had to vote in favor of it before it became law. It was, again, just another way of saying that this is not a top-down government. This is a government of the people. And they always believed that the states we've become a much more national nation over time, just because communication and interstate highways and now the internet and television and such. But back then, when you didn't have any of that, they believed all the activity was going to be in the states, because you know people in the states. Everybody knows everybody, and you're going to know your local legislator, and he's going to be there for 10 months out of the year, and maybe he'll go to Frankfurt every now and then and meet the governor and do what you want. So they wanted it to come from the states. They wanted approval of this new constitution to come from the states, because they knew that meant coming from the people. And that's exactly what happened, and it took a little while, but we fairly quickly got to the requisite number, and we got our Constitution.
We're about to wind down, Attorney Sullenger. We thank you so much, but how would you like, just take about 30 seconds, and how would you like to summarize anything before we say bye-bye?
Well, I just think it's important to remember we're in a time of upheaval now. We've got a weather catastrophe going on with a hurricane in Texas right now. We've recently had mass protests in a couple of communities with neo-Nazis fighting against mostly black groups. We've had a lot of consternation recently over police treatment of particularly black folk in cities big and small. We have a president who's, I will say, controversial in a lot of ways. And our system is strong. Our system has worked for 230 years, and we've done a lot of this before. A lot of people thought FDR was an authoritarian president, but he got us through the Great Depression. And then things calmed down. And then the 60s were a time of great upheaval with Vietnam and protests. And then things calmed down. And we see this cycle through our history, but I'm confident that we'll get through it as long as we have that speech article so that we keep talking to each other, and hopefully our politicians will follow suit, and I think things will work themselves out.
We really appreciate you being with us today. It's great information you've given us, and we appreciate you and all the questions. And we want to say thank you, and thank you for joining us today. And we hope to see you very soon. Bye-bye.